Hello, everybody. Welcome to 6 p.m. and the cocktail hour, and for couples only, how to use and hopefully not lose tenancy by the entireties protection. This is Alan Gassman. I'm going to start off with just a couple of announcements here. First of all, if you can't hear me well, and you're using your computer, you can call in with your cell phone, and from what I understand, that works a lot better. Secondly, if you have any questions or problems associated with this seminar, of course, you can call Janine at 727-442-1200 extension 8. She's standing by. Or you can email her, JANINE, at gassmanpa.com. And Janine, I'm hearing feedback, so I've asked Shuttle Control in Houston to try to fix the feedback, and we'll see how that does. Also, we are very open for all of your suggestions and questions about other topics. I think that our next topic is going to be the biggest mistakes that physicians make in medical practice and investment decision-making, and we'll soon announce that. And then we're also working on another one, which is the biggest mistakes that parents make raising their teenagers, and that's going to be interesting, and I'm not going to say much on that one, and either are my children. So anyway, the feedback should be better now, and we'll go ahead and get started. And you have two handouts. You've got an outline that you don't probably ever have to look at, but if you're a lawyer or a CPA, you may want to look at it. And then you have the PowerPoint, which is entitled For Couples Only, all about tenancy by the entireties. And I'm going to guide you with the fun red ball. If I could sing, I'd probably sing some of this, but I can't. And I'm starting on page 28, and then I'm going to go back to page 1. So what you see is page 28, and you see a chart here. And I just wanted to talk about how married couples can own their assets. Our seminar today is about tenancy by the entireties. That's what TBE stands for. Has nothing to do with tuberculosis. But when a husband and a wife jointly and personally own assets jointly, and it qualifies for tenancy by the entireties treatment, then if somebody gets a judgment against one spouse and not the other, they can't reach into the tenancy by the entireties assets, and that's the really neat thing about it. No matter how much I might be sued for no matter what I might do, my assets held jointly as tenants by the entireties with my wife are not touchable by the vast majority of creditors. We'll get into more detail on that. But to look at it from the 100,000 square foot view, the 100,000 foot up view, any person can own permanent life insurance and annuity contracts, and those will be creditor protected, and that's why a lot of clients do own those things. And then any person can set up a revocable trust, also known as a living trust, and put assets in the trust, and that won't protect assets from any credit. That won't protect any assets from creditors whatsoever. So a lot of people have these revocable trusts that we have set up for them for estate planning, and the life insurance may pour into the trust, but you don't necessarily want to put assets in the trust unless you check with the qualified lawyer. Now, the other spouse, and also, by the way, pension and IRA assets are going to be protected from creditors as well. Then the other spouse can have a revocable trust. Now, let's say in this situation, the husband is a neurosurgeon and the wife is a soccer coach. Well, there's a lot bigger chance of the husband being sued than the wife. So you might put assets under the wife's trust, but then if the wife is in a car accident or somebody sues her over a soccer game or a broken nose at a soccer game, she might lose them, so you want to make sure you have a lot of insurance. These people might also, I'm going to skip to page 29, these people might also have real estate, and they may want to own the real estate under a company as tenants by the entireties, which we'll talk about later, or under a family limited partnership as tenants by the entireties. And these people may also want to do some gifting for children into a special trust that doesn't benefit either spouse and can't be touched by creditors of either spouse, or even maybe a trust that the husband could fund for the wife in our example, which would be creditor-proof from the husband's creditors as long as the husband is not a beneficiary. So, going back to the beginning, trying to go back to the beginning. Sorry, I'm having a scrolling issue. And the scrolling issue is being resolved by Mission Control in Houston. Sorry for that delay. All right. Coming back, there's your webinar information. There's a blank screen. There's some quotes. My wife and I were happy for 20 years, then we met, by Rodney Dangerfield. There's a few other quotes. And then we'll go to the introduction. We told you what tenancy by the entireties means. This actually started in England, probably in the 1500s, where women were not allowed to own assets. So there would always be the desire to leave a woman a dowry, to give the woman a dowry on death, or to give or on marriage, or a gift. But the wife couldn't own property. The husband could own property, but he might lose it in a card game or based upon bad judgment. So they came up with this concept of tenancy by the entireties, where the husband and wife could together own the property as an indivisible unit, and it would take the signature of of both of them in order to lose it or to mortgage it. And that way the woman wouldn't have property, but the husband couldn't mess the property up. Okay, now when you have tenancy by the entireties, each owner is presumed to have an equal share, and it's not divisible by one spouse alone, as I said. It's not recognized in most states. Florida and Delaware are two of the states that recognize tenancy by the entireties for almost anything you can own. A lot of the states that recognize tenancy by the entireties only recognize it for ownership of real estate. All right, we talked a little bit about the definition of tenancy by the entireties. In order to qualify under tenancy by the entireties, both spouses have to take possession, ownership, and all rights in the assets at the same time. So, for example, if I had a bank account and I wanted to add my wife to the bank account, I would have to not just add her to the account, because then we would not have unity of time. I would have to set up a new bank account in our joint names and then transfer the money from the old bank account to the new bank account, and then we would have unity of time. A lot of unity is required there. Now, there was a ton of litigation over whether a joint bank account would qualify as tenancy by the entireties, because husbands and wives were setting up joint accounts as joint tenants with right of survivorship, and different courts were coming to different conclusions as to whether that would all be protected or only half protected. So the Florida Supreme Court, about 9 years ago, came up with a decision. And their decision is a little bit long-winded, pretty well written, and it basically says that if there is a tenancy by the entireties box to check, then you check that box. If there's a right of survivorship box to check, and you're not offered a tenancy by the entireties box, that's okay. It's confusing. But if you're offered both a tenancy by the entireties box and a right of survivorship box, and you check right of survivorship, then the creditor of one spouse can reach half of the assets in the account. Some banks have done a better job of helping make sure that their customers have tenancy by the entireties than others. Regions Bank has done a nice job. I've given you on page 7 the actual form that they have customers sign to help confirm that the account is a tenancy by the entireties account. A lot of clients set up joint accounts with pay-on-death features that I don't think are going to qualify as tenants by the entireties. Now, another example of tenancy by the entireties is a stock certificate. If my wife and I invest in a company, we get 20% of the company. They issue the stock certificate in our names. Is that joint with right of survivorship where it's not protected, or is it tenancy by the entireties? And the cases are still developing in this area. But it is certainly safest to make sure that the stock certificate says John and Mary Smith, as TBE. That's assuming, of course, that your name is John and that your spouse's name is Mary. Now, tax reporting can also be a factor, especially for you CPAs out there, and I'm proud to say there's several of you. The Internal Revenue Service gets a K-1 form from an entity telling it how that entity is owned. And if you are taking the position that you and your spouse own part of a company as tenants by the entireties, it would certainly be best for the K-1 form to show joint ownership and not one spouse or the other. Back in the flipper days, a lot of clients had a lot of their wealth in deposits on real estate. And when you put your name on a contract, John and Mary Smith, you would say John and Mary Smith, tenants by the entireties, not just John and Mary Smith, or it might not qualify as tenancy by the entireties property. Then here's one, U.S. Treasury bonds. These, by federal law, for some unknown reason, cannot be put in tenancy by the entireties. So if you're going to buy U.S. Treasury bonds, you might put them in a special type of partnership, or put them in the name of the spouse who coaches soccer and not the one who does the neurosurgery. Another hot topic in the tax area, in the law area, is tax refunds. There are cases which indicate that when you get a tax refund as a result of filing a joint tax return, that will be a tenancy by the entireties asset if you deposit it in a tenancy by the entireties account. So let me take a break here from the tenancy by the entireties topic and talk about the concept of a fraudulent transfer, because many clients don't really start thinking about how their assets are held or how they're supposed to be held until a creditor is on the horizon, and then there's a concern that the transfer of the asset from one median to another may be thought to be a fraudulent transfer and may be set aside by a creditor. If I get a tax refund in my personal name, or I deposit a joint tax refund into my personal account, and then it goes from there to a tenancy by the entireties account, that might be a transfer that a creditor of mine could set aside if they could show that I made the transfer to avoid them. But a transfer from one exempt type of asset to another, such as a transfer of a tax refund check to a tenancy by the entireties account, or a transfer of a wage check that would be protected under the creditor law to a tenancy by the entireties account, will generally not be deemed a fraudulent transfer. So a lot of clients have a wage check, and if you earn a wage as a salary and you're the head of your household, you have a good chance of protecting that wage check from creditors, and you can deposit that wage check directly into a tenancy by the entireties account or something similar to that. Now back to the outline, or the PowerPoint rather, at page 13, what about furniture, equipment, jewelry, and things like that? Well, under a recent court case called the Matthews case, it will be presumed that you own the grill in your backyard as tenants by the entireties, and presumed that you own your dog and your doorknob collection and all those phone charges that don't fit into any of your phones. Those are all considered tenancy by the entireties if they're in Florida. If they are in North Carolina, Washington State, Colorado, they are probably not protected because those states don't recognize tenancy by the entireties. Some clients have had us put their physical collectible assets into LLCs because it's easy to make sure that the stock of an LLC is owned as tenants by the entireties, and then that LLC might own the collectibles, the artwork, and things like that. Now, how about automobiles? Well, this is strange, but of course we're talking law here, so strange is not unusual. If you registered the car title to say "and," then the car is owned as tenants by the entireties, and a creditor getting a judgment against one of you can't reach that Rolls Royce or that Mercedes. On the other hand, if you registered the vehicle as OR, then it's not going to be protected as tenants by the entireties, and the creditor is going to be able to force a sale of the car and get to half of it. On the other hand, and this is the crazy part, if you die and the title says and, then we have to do a probate proceeding to have the survivorship apply. But if you die with or, then there's no probate. So just an interesting thing on cars. Now, as you know, if you viewed one of our prior webinars, we don't recommend that people own their cars jointly, because if the car gets in an accident, both owners might be responsible. So we would typically not have a car owned jointly, but if you've got a Bentley or a Rolls-Royce, and usually it sits in the driveway, you might want to have it owned as tenants by the entireties. Okay, real estate owned outside of Florida. This will be protected as tenancy by the entireties only if the other state recognizes tenancy by the entireties. So most of our clients have their out-of-state real estate in Georgia, North Carolina, Washington, and Colorado. And Georgia, Colorado, and Washington don't protect tenancy by the entireties. Some states have tenancy by the entireties, but don't provide full protection of assets for them, like Alaska and Tennessee. Now, some other notes on tenancy by the entireties. A 3-person account won't work. A tenancy by the entireties bank or brokerage account has to be solely between a husband and a wife who are married at the time the account is open. You can't put your mother-in-law on that account, or a creditor will be able to reach your half or third, depending upon how it's looked at. Tenancy by the entireties is only owned by 2 people who reside in tenancy by the entireties states. I don't think that I can have a tenancy by the entireties account with my wife if my wife moves to California, because they don't recognize tenancy by the entireties assets. Okay, I just wanted to briefly mention at page 17, joint debt and bankruptcy. If I own an account with my wife as tenants by the entireties, and someone gets a multi-million-dollar judgment against me, then I would hopefully be able to file bankruptcy, eliminate the judgment against me, and the creditors would not be able to touch the tenancy by the entireties assets, and my spouse would therefore not suffer whatsoever, any more than she does now, by the way. So there's an exception, though, that if you file bankruptcy and you and your spouse have both tenancy by the entireties and also non-homestead debt, then you may be required to forfeit the tenancy by the entireties assets in order to get the joint debt paid. So this will not apply to the homestead, but if you and your spouse have debt other than your homestead, you want to be able to satisfy that debt before you would file bankruptcy, because this rule may apply to you. One result of this rule is that when a client invests in real estate or something like that where there's going to be a large loan, we put the real estate into a limited liability company or a limited partnership and have the client be a guarantor on the loan but not the actual obligor. That way it doesn't become joint debt. And of course, if you can avoid having your spouse guarantee an obligation, that is also good planning. Okay, back to the estate planning point of the situation. It's not uncommon for lawyers to attempt to draft trusts that would qualify as tenancy by the entireties. John and Mary Smith could set up the John and Mary Smith Revocable Trust. They're trying to avoid probate. They're trying to avoid guardianship. But unless that trust is very specially drafted, it is not going to qualify as tenancy by the entireties property. And therefore, in the last couple of years, and I guess about every year, we have the occasion to counsel somebody who thought that they were going to protect their assets by placing their assets into a joint revocable trust, and then found out that when one of them got sued or might have been sued, that the assets in the joint trust were at least half exposed to creditors. So you want to be careful on the joint trusts. And I do have an article in the outline talking about joint trusts and separate revocable trusts. Now, in the next slide, I have the schematic of a typical revocable living trust. Typically, each spouse, when they're clients of ours, and I think clients of most qualified lawyers in this area, each spouse would have a separate trust. This might be my trust right here. On my death, my life insurance, my annuities, even my pension could go into a trust called a family or a bypass trust that could benefit my wife without being subject to federal estate tax at her level. So I might own my life insurance policy so I can access the cash value, which is creditor protected, and I may have it payable to this trust. Now, if I die, all my tenancy by the entireties assets are going to pass to my wife and not to under this trust. However, under the Florida statutes, when one spouse dies, the surviving spouse can file for a disclaimer of 1/2 or sometimes more of the joint asset into the estate of the first dying spouse. So in my situation, and for many of you who are listening, if you die with joint assets, your spouse could disclaim inheriting her part or his part, and then that would pass by will back into your trust to fund the bypass trust. A lot of estate planners aren't aware of that, and they have clients divide up half of the assets into the name of each spouse, and then they're exposed. So it's safer to have separate trusts in TBE and to use a disclaimer if that day comes. Of course, there's more complexity to that than you want to hear about tonight, but I wanted to cover it. Another thing I thought would be of interest, and by the way, our law firm does not sell life insurance or accept any financial compensation from any insurance agency or carrier, even though some of them are our friends. But in many cases, the husband and a wife owning a lot of tenancy by the entireties assets have a concern that if the wife's soccer coach dies, the husband neurosurgeon suddenly owns all of the TBE assets and they're exposed to creditors. So we'll often recommend a term life insurance policy on the life of the soccer coach, which, for example, on page 22, a 10-year term policy if she is in standard, physical condition would be about $500 a year for $1 million, and that $1 million would then be paid into the bypass trust on the soccer coach's death, so that the neurosurgeon would have access to those assets and investment control of those assets without having them exposed to creditor claims. So I suspect that some of you listening will probably have an interest in getting some term life insurance into place, and there's a little bit of guidance on that on page 21, which is you can call an independent agent, have a physical taken, tell the agent you don't want any formal applications to be sent. You want to keep them informal until the results come in before you give any formal information to an insurance carrier, because once you give them formal information, it goes on the bureau and they know it forever. If you're a 50-year-old, then that insurance is more expensive. For a lady 50-year-old, anywhere from $1,000 to $1,600 a year for $1 million 10-year policy. But it can make a lot of sense. And while you're at it, you may want to make sure that the primary wage earner has plenty of coverage as well. So some practical considerations. Number one, what if both spouses get sued? Well, then you don't really have much protection. That's where you might be using a family limited partnership or a family LLC, like I'm going to mention in a minute. Number two, what if the non-debtor spouse dies while the debtor spouse is waiting for a jury verdict? Well, if it looked really bad, you could move all the assets to the revocable trust of the non-debtor spouse, and they would all be captured and protected on the first death. But having that term life insurance in place helps as well to substitute for the assets. Three, what if the spouses get divorced? Well, that's where you would probably want to have a family limited partnership or an LLC if there's any assets left after the divorce lawyers get their share. Number four, what if the law changes? Well, that's where we like to have the belt and suspenders approach, getting you back to the chart we started with. Actually, the page after that shows you that oftentimes we will have the tenancy by the entireties assets under a family limited partnership or an LLC owned perhaps 97% by the husband and wife as tenants by the entireties, and maybe 3 or 4% or 5% by an irrevocable trust for the children. Then and by the way, these TBE lines should go directly to the husband and wife, not to these trusts. We'll fix them next time. But as I was saying, if somebody gets a judgment just against the husband or just against the wife, they can't touch this. If someone gets a judgment against both the husband and the wife, then they cannot penetrate and take control of a family limited partnership. They just get something called a charging order. And if you don't know what a charging order is, I'll be glad to send you information on them, but it's not very easy for a creditor to get assets out of an entity once there's a charging order, when they get a judgment. For example, if I owe somebody $1 million and I own 95% of a partnership, the court will order me to turn any partnership distributions in the future over to the creditor, but cannot order the partnership to give me distributions. We thought we had the same protection for limited liability companies, and we might, but the Florida Supreme Court recently released a case that I believe will be viewed as highly controversial, finding that charging order protection may not apply in a multiple member LLC situation. So I think limited partnerships are going to be favored over LLCs. The other thing that's nice about the family limited partnership or the LLC is the annual gifting. Instead of gifting money every year to this trust for the children, you can just give maybe 3% a year, and that translates out to a gift to the children. Maybe if it's worth $26,000 a year and it grows at 7% growth, it might be worth $360,000 after 10 years. But if you are giving only a partial interest in a limited partnership or an LLC, then you might be able to take a discount and really be gifting $40,000 worth a year. So the cumulative growth at the end of 10 years, assuming that the assets can grow at 7%, would be $552,000, and the difference you've made for the next generation as far as this little annual exclusion gift is $193,000 in 10 years. So that's a good business reason that we often set these limited partnerships up beyond the fact that they're good for creditor protection and controlling spending and things like that. And then the last page is a memo that we sent to professional advisors on the 26th, reminding them about this late June Florida Supreme Court case where the court held that if you own part of an LLC, well, the court held that if you own 100% of an LLC and you get a judgment against you, the creditor can take over the LLC. The court seems to think that if you own, for example, 95% of an LLC and the creditor gets a judgment against you, that they can take over your 95% of the LLC. They didn't hold that directly, but they seem to be of that opinion, so it is of concern. Okay, I've got about 2 minutes here, so I thought I would answer some questions, and I have a lot of good questions, but I'm going to narrow this down to the ones that I know the answers to. And the first one is, how should a new car be titled? Well, most commonly, it would be owned by the spouse who drives it the most often, because that spouse is going to have owner liability if there is owner liability, and that we don't really want joint liability. But you may take a 60-month car loan or a 48-month car loan or maybe even lease the car, because then a creditor wouldn't want it if they were trying to get it. And we do have a whole article on vehicle ownership protection for Floridians that we'll be glad to send you if you send us an email. Then another one, if I have an LLC and my wife owns it jointly with me, is it disregarded for federal income tax purposes, or should it file partnership tax return? Well, Tom, that's a great question. There is authority for the proposition that a husband and wife can jointly own an LLC and that it will be disregarded for income tax purposes. And that is in a publication called Bureau of National Affairs, also known as B&A, their portfolio on disregarded entities. So I think that that's safe. Now, the IRS may have a different opinion now or someday in the future. They may want you to file a partnership tax return. The nice thing is that the tax difference between husband and wife being disregarded and owning a joint LLC or being taxed as a partnership will rarely make any difference. So that's a good thing. You wouldn't expect to have penalties or anything like that. Next, if you own property jointly with somebody else and your spouse, will that qualify as tenancy by the entireties? Well, as I said before, If you have multiple names on a bank account, it will not qualify as tenants by the entireties. On the other hand, if you and your spouse own a vacation home or stock in the company, and you have somebody else's name on the stock, that may still qualify, your portion may still qualify as tenancy by the entireties, as long as the wording is done right. I can't overemphasize how often we see limited liability companies where people form them themselves, and then they get the forms from somewhere, or they don't do the forms, or they get somebody who puts it together wrong, and then that LLC cannot qualify as tenancy by the entireties because the paperwork is simply done wrong. So it's important to check the paperwork. I mean, if I have anything to close with you now, as my closing point, it is you have to check the paperwork. Just because the accountant thought it was joint and put it on the bank account, put it on the financial statement that way, just because the tax return says it's that way, just because your partner told you that was that way, just because you told the banker you thought it would be that way, that is not definitive of how something is held. You need to actually look at the bank account agreement, look at the operating agreement and the stock certificates of the LLC, look at the contract, and determine whether those things, number one, can be owned as tenancy by the entireties, and number two, whether they are in fact owned as tenants by the entireties. And remember, it was not raining when Noah built the ark. So I'm going to close now. I promised everyone we'd be done in 30 minutes. It's 31 minutes, and I'm going to answer any questions going forward by email. Thank you very much, and have a fantastic evening with your spouse.